Thank you, Jeremy, and good morning, everyone. Thank you for joining me in the midst of this holiday week. And I'll start by re-emphasizing that I'm speaking today in my personal capacity, and my opinion is my own and not that of the National Geospatial Intelligence Agency, the Air Force, or the Department of Defense. So here's a preview of what I plan to cover this morning. I'm going to speak for about 30 minutes. I've got 18 slides that feature cool space pictures from NASA. And as Jeremy mentioned, I'll be presenting a version of a paper that I've written that you can all read next year at the Journal of National Security Law and Policy. With that, why don't we get started with the next slide, please. The quotation you see on this slide is probably familiar to you. I'm guessing it's the reason you decided to join me in a webinar about the global commons this morning. It says outer space is a legally and physically unique domain of human activity, and the United States does not view it as a global commons. This, of course, comes from the executive order on encouraging international support for the recovery and use of space resources, issued by the president back on April 6th of this year. I found this executive order to be interesting for a few reasons. As an order from the president is an example of subsequent state practice on the interpretation of the Outer Space Treaty. This means it can help to shape interpretation of ambiguous provisions of the treaty, like the non-appropriation principle. On a related note, I found it interesting as a bridge between the 2015 Space Resource Exploration and Utilization Act and the Artemis Accords, which were first issued after this executive order. And now we can add to it the 2020 National Space Policy. Taken together, these pieces are laying the groundwork for establishing broad, or at least broader, international acceptance of the US view that private property rights can be asserted in space resources. But finally, I found the executive order especially interesting for this fleeting reference to the global commons. So this morning, I'll touch upon various issues raised by the executive order, but my focus will be on this sentiment about the global commons. Next slide, please. So as a national security law practitioner, I thought I had a basic grasp on the term global commons. So when this executive order came along, and declared that outer space is not a global commons, for me, it raised as many questions as answers. First, what is a global commons? How do we know that outer space is not a global commons unless we first know what a global commons is? And second, if we can define global commons and determine that outer space is not one, then why not? What's the reason? The executive order did not get into these kinds of details, but these are the questions I want to explore here today. Next slide, please. So let me begin by establishing a premise. My premise is that the term global commons has no authoritative definition. This does not mean that it cannot be used illegitimately, and I'm not suggesting that the term can or should be used to mean whatever you want it to mean. I'm suggesting that legitimacy comes from commonly accepted uses rather than any single authoritative source. And with that premise in mind, here's my argument. In my view, the term global commons is used as a label for a concept. And there are two main concepts that it can label. I call these an enabling concept and a constraining concept. So right away, we can see the challenge with this term. When someone uses the label global commons, the intended meaning may be unclear to the audience. You may associate the term with one meaning, but your audience may associate it with a different meaning. So we are starting to get a sense of why many people view this term as problematic, and rightly so. So over the next several slides, I hope we will get a better understanding of why that is. On to slide 5, please. Let's now examine these concepts further, starting with the enabling concept. The reason I call it the enabling concept is because in this concept, the global commons play an essential role in enabling prosperity and security. The quotation on this slide exemplifies this concept. It's from a 2016 report by the chairman of the Joint Chiefs entitled Joint Operating Environment 2035. It says open and accessible global commons are the pillars of the current international economy and empower states that use them to conduct commerce, transit, scientific study, or military surveillance and presence. Next slide, please. Context matters. If the context is military or geopolitical, then you are likely to see global commons being used to refer to the enabling concept. And when it is used in these contexts, it is generally used to refer to an area that falls outside the jurisdiction of any state, but which states and their nationals can freely access and use. A classic example of the global commons is the high seas. Look at Article 87 of the UN Convention on the Law of the Sea. It's titled Freedom of the High Seas and declares that the high seas are open to all states. So to paraphrase Joint Operating Environment 2035, the basic idea is that the high seas empower states that use them to conduct commerce, transit, or military surveillance and presence because they are open and accessible as global commons. Next slide, please. So as I said before, legitimacy comes in large part from common usage, and this is a very common usage of the term global commons. This slide lists some of the entities that have recently used the term global commons as a label for what I'm calling the enabling concept. The Department of Defense, for example, has used it this way in numerous policy documents. The Congressional Research Service used it this way this year in 2020. Also, the US-China Economic Review Commission and the RAND Corporation and the Heritage Foundation, also in 2020, and the Center for Strategic and International Studies, also 2020. The list could go on and on. These are just some examples of the government entities and think tanks that have used global commons to refer to an area outside of the jurisdiction of any state that plays an important role in prosperity and security. Next slide, please. So we know we can find many examples of global commons being used as a label for the enabling concept, but what about outer space in particular? When people use global commons this way, are they including outer space? And the answer is yes, this happens all the time. It's not hard to Google recent examples of prominent people referring to outer space in this way as a global commons. And here's a sample. Secretary of Defense, Mark Esper, former Secretary of the Air Force, General David Goldfein, Professor John Yoo, who actually published a space law article in 2019, General John Hyten, current Vice Chairman of the Joint Chiefs and former Commander of Air Force Space Command and U.S. Strategic Command, General James Cartwright, former Vice Chairman of the Joint Chiefs, and Admiral Cecil Haney, former Commander of U.S. Strategic Command. In a moment, we'll get into why these people may be able to justify calling outer space a global commons as a matter of law. But before we do, let's move on to the other concept we sometimes see associated with this term, the constraining concept. Slide 9, please. You may find that global commons is not always used in a military or geopolitical context. Sometimes it is used in an economic context. When this happens, it is being used as a label for what I call the constraining concept. It's constraining because it is often associated with notions of shared ownership or limitations on use. The word constraining may have a negative connotation, but that's not my intention. Whether these types of constraints are viewed as positive or negative is really a matter of subjective opinion. On this slide, you see a quote from a presentation at the Copious Legal Subcommittee meeting in 2017. It says, outer space and celestial bodies, including resources thereof, are global commons under the sole jurisdiction of the international community. This was stated in the economic context of space resource exploitation. It was argued that exploitation requires interest balancing. Overall, I would say this sentiment provides a pretty good example of global commons being used to express a constraining concept. But what exactly does global commons mean when it is used in this sense? I think it depends. Let's move on to slide 10 and I'll explain why. The idea of the commons has a long intellectual history and I don't pretend to be an expert. With that in mind, what I'd like to do is briefly single out the works of Gerhard Harden and Elinor Ostrom. Gerhard Harden published an influential article in 1968 in Science magazine called The Tragedy of the Commons. Harden postulated that individual actors will tend to overexploit common resources that are freely available to everyone. According to Harden, the solution to avoid the tragedy of the commons was to enclose those resources through private property or to impose public regulation. This became a kind of conventional wisdom. Then a political economist, Elinor Ostrom, came along and upended that conventional wisdom. She gained recognition for her work showing how these common resources, which she called common pool resources, can be made sustainable when stakeholders adopt a polycentric and self-regulating mode of governance. She won the Nobel Prize for her work in 2009. Under Ostrom's influence, the idea of the commons, for some at least, took on a fuller meaning that speaks to ownership, management, and governance. One commentator's quote shown at the bottom of this slide exemplifies that view. The commons is less a description of the resource and its characteristics and more of a normative claim to the resource. Next slide, please. So as this very brief summary suggests, the commons in an economic context has taken on two possible meanings. The first simply refers to a particular category of goods. This usage was typical prior to Ostrom's influence. This meaning does not imply any particular type of ownership regime. It is just a reference to a category of goods. The second meaning reflects Ostrom's influence. It implies a legal regime is associated or should be associated with those goods, and that legal regime is one of collective ownership or collective management. As we saw on the previous slide, it is more of a normative claim to the resource. So in summary, we have two different meanings for the constraining concept. They are related, but they are not the same. It is important to recognize the distinction because failing to differentiate between the two or using them interchangeably will likely create misunderstandings. Just as using the term global commons as an interchangeable label for the enabling concept and the constraining concept will create misunderstandings. Slide 12, please. And where can we see global commons used this way? Well, we need to look no further than the executive order itself to see global commons used as a label for the constraining concept. One of the clues is the context. The economic context is clear from the name of the order itself. Encouraging international support for the recovery and use of space resources. The structure is also an indication of the economic context. And Jeremy, if you would, I think this slide has a build. If you could just advance it. There we go. As you can see here, the sentence that says the US does not view space as a global commons is sandwiched between two sentences that both refer to the commercial recovery and exploitation of space resources. Another clue is that we know where the executive director of the National Space Policy stands on this matter. Dr. Scott Pace said in 2017, outer space is not a global commons. And he said, to unlock the promise of space requires that we not constrain ourselves with legal constructs that do not apply to space. He literally used the word constrain. So there's little doubt, I think, that a key figure behind the executive order associates global commons with the constraining concept. Now, as I've argued, the constraining concept has two different meanings. So which meaning is expressed in the executive order? I think both meanings are. The order doesn't provide much by way of explanation, but it seems to base its determination on space being a legally and physically unique domain. This suggests there is both a legal reason and a physical reason underlying the determination that space is not a global commons. In my opinion, the physical aspect can be understood as referring to the first definition, that is, the category of goods, and the legal aspect can be understood as referring to the second definition, which is the separate question of ownership and governance of those goods. So I think we can conclude that the executive order is telling us that outer space is not a global commons in either meaning of the constraining concept. It also does not differentiate between the constraining concept and the enabling concept. It simply says we do not view outer space as a global commons, period. This raises the potential for confusion that I will address more later on. Next slide, please. So far, we've addressed the first question I raised: what is a global commons? We've identified two different concepts and three different meanings. The enabling concept is used in military and geopolitical contexts, and it means an area beyond national jurisdiction of any states, but which is free for states to use and access. The constraining concept is used in economic contexts and can mean either a category of resources or the collective management regime that can apply to those resources. Which brings us to our second question. If we have a sense of what global commons means, then do any of these meanings apply to space, and why or why not? In short, is outer space a global commons? Next slide, please. Let's first look to the enabling concept. Is it accurate to include outer space among the global commons that belong to no state, but which states are free to access and use? I would submit that the enabling concept is firmly grounded in the Outer Space Treaty. Article 1 guarantees the right to use space freely and access celestial bodies. It declares outer space, including the moon and celestial bodies, shall be free for exploration and use by all states without discrimination of any kind, on a basis of equality and in accordance with international law, and there shall be free access to all areas of celestial bodies. In addition, Article 2 guarantees the lack of national territorial jurisdiction, which is another defining trait of global commons. Article 2 declares space is not subject to national appropriation by claim of sovereignty, by use or occupation, or by any other means. Also, Article 12 contemplates the permissible occupation of territory by installations on the moon, but that they be open and accessible to other states parties to the treaty on the basis of reciprocity. And this further reinforces the right to access. So in short, the concept of global commons is grounded in the Outer Space Treaty if you are talking about the enabling concept. Next slide, please. Turning now to the constraining concept, let's start with the first of the two possible meanings. Is outer space a global commons if by global commons you simply mean a category of goods of the kind that Elinor Ostrom might call common pooled resources? If this is your definition of commons, then calling outer space a global commons is problematic. As one commentator observed, this would be a sweeping generalization and an utterly meaningless statement. This is because outer space is far too vast, with far too many resources of different kinds, to say that they all fit into one particular category. You would never say all of Earth is a global commons, and for the same reason, it makes no sense to say space is a global commons. On the other hand, if you are more specific about which resource in outer space you are talking about, then it could make sense to call a particular resource a commons. For example, look at the Napa report. As many of you will have seen, in response to Space Policy Directive 3, Congress commissioned a report by the National Academy for Public Administration to assess which government department or agency is best suited to take on space traffic management. The Napa report noted that the heavily used regions of LEO and GEO are both rivalrous and congestible and can be thought of as common pool resources. In other words, the August 2020 Napa report has identified particular resources in outer space as common pool resources, or commons, in the sense of a category of goods which it defined as rivalrous and congestible. Slide 16, please. Let's now turn to the other possible meaning within the constraining concept. Under this meaning, global commons has a legal connotation. It implies a legal regime is or should be associated with those goods, and that legal regime is one of collective ownership or collective management. The first place we should look to see if the notion of the global commons has any basis in international space law is, of course, the Outer Space Treaty. Again, our focus is on Articles 1 and 2, the freedom principle and the non-appropriation principle. Fundamentally, With regard to property ownership under the Outer Space Treaty, the question of the recovery or use of resources in space, commercial or otherwise, is a question of whether recovery constitutes a permissible use under Article 1 or a prohibited appropriation under Article 2. As many of you know, the US has long held the position that Article 2 prohibits claims to resources in place, but does not prohibit claims of ownership over resources that are removed. Under this interpretation, removal is a form of use permitted under Article 1. We have seen this interpretation recently reaffirmed in Title IV of the Space Resource Exploration and Utilization Act, which was part of the 2015 Space Launch Competitiveness Act, as I mentioned earlier, and again this year with the Artemis Accords and the 2020 National Space Policy. It's important to keep in mind that not everyone agrees with this interpretation, and oftentimes this disagreement comes down to the distinction between territory and resources. In other words, we all agree, for the most part, that no one may claim territory in space because of Article 2. However, as Ben Cheng has observed, space resources raise a separate question. Space resources are not necessarily regarded as equivalent to territory when interpreting the non-appropriation principle. In the US view, space resources are more like fish in the sea. You can take the fish out of the sea without claiming the sea for yourself. And speaking of territory, let me digress for just a moment. What about the semi-permanent occupation of territory on the moon in order to extract resources? Again, this is best framed as a question of whether such occupation would be considered a permissible use under Article 1 or a prohibited appropriation under Article 2. Article 12 also factors in because it expressly permits moon installations while affording the right of free access to such installations on the basis of reciprocity. Next slide, please. So as I said before, Global Commons has no authoritative definition, but legitimacy comes from commonly accepted usage. One possible usage is to associate Global Commons with the common heritage of mankind principle found in the Moon Agreement. While I would not necessarily say this is a commonly accepted usage, it is worth thinking about because it is not unheard of to see these two ideas linked. So first, some quick background on the common heritage of mankind principle. It's found in Article 11 of the 1979 Moon Agreement and creates a new type of territorial status. In the words of Ben Cheng, under this new status, the moon and celestial bodies are not only in themselves not subject to national appropriation in the territorial sense, but the fruits and resources of which are also deemed to be the property of mankind at large. Also, everybody knows the US is not a party to the Moon Agreement, and the executive order reiterates clearly that the US rejects the Moon Agreement. And finally, I would add that it is easy to conclude that outer space is not a global commons if you associate global commons with the common heritage of mankind principle. If, for example, you come across an argument that the US and the world rejected the Moon Agreement and therefore rejected outer space as a global commons, then you have come across an argument premised upon associating global commons with the common heritage of mankind principle. If you do come across this argument, keep in mind that it may ignore the possibility that the constraining concept's application or non-application, as the case may be, to outer space may be grounded in the Outer Space Treaty as opposed to the Moon Agreement. Next slide, please. In conclusion, it comes down to this. Whether or not space is a global commons depends on what you mean by global commons. So where do we go from here? As a practitioner trying to make sense of this term in light of the executive order, I think we could draw three lessons. The first is that all domains are affected by this executive order. The order did not say outer space was not a global commons depending on the meaning. It simply said outer space was not a global commons. This is an implicit rejection of all possible meanings as applied to outer space. But if outer space is not a global commons in any sense of the term, then by what logic can we continue to call the high seas a global commons? If we are being consistent with our terms, either both are global commons or neither are, So I don't see the logic in calling one a global commons and not the other, unless we were to add caveats that are not found in the order itself. In fact, I would argue that the order is a further indication that the term global commons has been abandoned altogether within the US government, or at least within some quarters. Look at the unclassified summaries of the current national security strategy and the national defense strategy. They both very clearly embrace the enabling concept, but they both apply a different label to it. They use common domains instead of global commons. If we step back and look at all these pieces together, I think the lesson is that common domains is preferable to global commons. But why is that? In my view, the correct reason is because common domains is simply less likely to be misunderstood, not because global commons is necessarily inaccurate. The distinction I'm trying to get at is this. Not saying outer space and the high seas are global commons is different from saying outer space and the high seas are not global commons. I'll say that again. Not saying outer space or the high seas are global commons is different from saying outer space and the high seas are not global commons. The question of accuracy brings me to the second lesson. Discourse about the global commons is not as straightforward as the executive order may suggest. Global commons has multiple legitimate meanings, and they apply to outer space in different ways. It would be fair to say that outer space is a global commons in the sense of being a domain beyond national jurisdiction and with free and open access, but is not a global commons in the sense of being commonly owned, such that nations cannot assert property interests in space resources. Both of these statements find support in the Outer Space Treaty. It is also not a global commons in the sense of being a singular type of open access resource, and yet particular resources within outer space may be regarded as such. Accuracy depends on what you mean by global commons. Accuracy in discourse on this topic will require using language with precision and using it consistently. And finally, the term global commons is a distraction, and it will remain a distraction. It's a distraction because there are multiple meanings which can lead to misunderstandings. The executive order may have sought to put an end to these misunderstandings once and for all, but it actually may have had the opposite effect by stirring up a debate where these misunderstandings about the global commons will continue to proliferate. The response, I think, is to change the terms of the discourse. As practitioners, let's not focus on labels. Let's not focus on whether or not outer space is a global commons. Let's focus instead on the concepts underlying those labels so that we can get to the heart of the matter. What is authorized under Article 1? What is prohibited under Article 2? And what should the law or policy be going forward? These are the questions we should be raising, and these are the concepts we should discuss. And with that, why don't we move on to the last slide? And I'd be happy to attempt to address any questions you may have. And once again, thank you for joining me this morning.
So Captain Keith Gibble, I hope I'm pronouncing that correctly, asks John, if 90% of the world's goods travel via, quote, the high seas, is the concept of global commons vis-a-vis high seas considered an example of the enabling or constraining concept, or both? If so, is this distinction helpful?
I think it much, as I said, much depends on the context in which you're using it. So I believe there can be overlap, and that's why the context is so important. If you're talking about it in a military or geopolitical context, then I think that would be an example of the enabling concept. But there's so much overlap that the context can blend, which is why the term is so problematic.
Is a question from Selena. She says, thank you for your perspective, sir. Do you think a distinction should be made between the high seas and outer space, and that the high seas are a physical medium, whereas space is a void with physical mediums scattered throughout it?
I think that kind of distinction would be focusing on the physicality of space and the seas. So if you're thinking about space in a geopolitical context and how you use it, I think that you're not thinking of it as a thing, the way you might in a different context. So for that reason, I reiterate that the context matters, and in the geopolitical or military context, the use of it can kind of be a more important element than thinking of it as a res or as a thing, which is problematic.
Professor Charles Stotler asks, is there a risk that an official statement that outer space is not a global commons could be interpreted as a repudiation of aspects of the Outer Space Treaty, particularly Articles 1 and Article 2?
Well, yes, I think that the statement has in mind the constraining concept, and so it is a repudiation of certain interpretations of the Articles of the Outer Space Treaty. So I think you kind of have to unpack it, as I've tried to do, to understand what it's repudiating and how. But I think that is because the meaning it's getting at is referring to the constraining concept, and it is indicating a preference of one interpretation of the treaty over another.
Great, thank you, sir. Colonel King asks, in the tragedy of the commons part, I think that you noted that both private ownership or public regulation could work for preservation. Did you find evidence of the US government leaning toward the private ownership model as a way to preserve the commons while still rejecting that term or the constraining concept?
I think we could draw that conclusion, but the order doesn't take us there. The order just tells us what about the rights that we view are exist in the Outer Space Treaty, without giving us a roadmap to which type of governance model we would need in the future. So I think there's more to be said. I don't think we have a clear direction on that.
Major Alcantara asks two questions. First question, where does the global commons concept fit with space debris / Kessler syndrome type issues, especially if one cannot determine the origin of space debris, yet there's this impact of space debris that affects everyone within this environment? And then I guess let's stop and take question 1 first, and then we'll go to question 2.
Where does it fit within the space debris issue? Again, I think that it depends on what you mean, and I think this goes to one of the points I made at the end, where it's more useful to talk about the concepts that are underlying the label. So I don't know what one might try to convey by associating the label global commons to the space debris issue. But if it might be more helpful if we just talked about the underlying concepts in order to not talk past one another.
Awesome. And Major Alcantara's second question is there a risk that a view that if space is not a global commons, that this view may encourage bad behavior that could affect future space operations?
Again, I think that what the risk of not viewing space as a global commons is in the eye of the beholder, depending on what meaning you associate to global commons. I just reiterate that I think talking about the concepts is more helpful than throwing the term around, because we take different meanings from it.
Follow-up question from Captain Geibel. Is Antarctica instructive in drawing a distinction concerning these issues of global commons or the underlying concept of a common?
Not sure how instructive it would be. It's as far as the enabling concept, it doesn't fit nicely into many definitions because there are lots of agreed upon restraints to access and use. So in that way, it's different than space in the high seas. So I guess I would say if at least if you're talking about the enabling concept, then it's not necessarily helpful in that sense.
A question from Major Brian Green. How does the quote, on the basis of reciprocity language in the Outer Space Treaty help us to understand the extent of states' rights to exploit territory and resources on celestial bodies?
Well, as I recall, that's the basis of reciprocity comes from Article 12, talking about access to insulation. So I wouldn't, unless I'm overlooking other places where it's mentioned, I wouldn't necessarily look to that for the anything other than access. So not necessarily to use. But I'd also add that we don't have any state practices that I'm aware of really telling us what on the basis of reciprocity means. So it doesn't tell us much yet, but maybe it could in the future.
Thank you, sir. Question from Professor Michelle Hanlon. Nomenclature is so important, and I feel like the term global commons is so fraught, right, as you kind of explained during your presentation. Is there a term that you'd like to see the international community start to embrace that more fittingly describes the status of outer space?
If you're talking about the enabling concept, then I think what the US has done recently with regard to referring to it as common domains is very useful because it avoids that fraught term. If you're trying to convey something to do with the constraining concept, then I don't know what term would be better because it could have the same problems, and I think we'd be better off just talking about the concepts that we may have disagreements about. What's permissible use, what's prohibited appropriation. Use the language of the treaty rather than labels, which I don't know that one would be any better than global commons.
All right, seeing nothing further. John, do you have any final words before we hand it back over to Jeff?
Just again, thanks everyone. It's great to see some familiar faces and names, and I'm glad you listened in. Thanks again.